Judgment in the appeal of the Queen and the 8th.
Lord Tilson will explain the judgment of the court.
The respondent in this case was charged with a money laundering offence under section 328 of the Proceeds of Crime Act 2002. That section states, a person commits an offence if he enters into or becomes concerned in an arrangement which he knows or suspects facilitates, by whatever means, the acquisition, retention, use or control of criminal property by or on behalf of another person. It's one of a number of money laundering offences under the 2002 Act. At the close of the evidence, the trial judge ruled that the respondent had no case to answer. The prosecution appealed unsuccessfully to the Court of Appeal. Whether the ruling was correct raises questions of law of some importance about what the offence involves, and in particular, what is meant by the expression criminal property. The prosecution arose from an insurance fraud orchestrated by someone I will call B. B later pleaded guilty to a number of offences and was sent to prison. His dishonest scheme was very simple. He established a number of ghost websites in the names of supposed insurance companies, falsely pretending to offer cut-price motor insurance. It was entirely fictitious, and members of the public who were duped into paying what they believed were insurance premiums got nothing for their money. B used accomplices to open bank accounts to receive the payments from the public. At B's instigation, the respondent opened two bank accounts, one with Lloyds and the other with Barclays Bank, but the accounts were operated by B. Over £500,000 was paid into the two accounts. The charge against B was in these terms, that between certain dates, he entered into or became concerned in an arrangement which they, that's he and B, knew or suspected would facilitate the retention, use or control of criminal property, namely money received into a Lloyds Bank account and a Barclays Bank account from the sale of motor insurance through the specified website by or on behalf of B. The court below ruled that criminal property meant property which already had the quality of being criminal because it was derived from some earlier crime at the time of the alleged money laundering offence. The prosecution argued that this gave the expression criminal property far too narrow a meaning, but this court is unanimous in agreeing that the courts below were right in that respect. But that is not the end of the matter. The money paid out by the victims was not criminal at the time when they paid it, but it became criminal property in the hands of B once it entered the bank accounts opened by him. The arrangement with which he was charged was an arrangement which, it's alleged, he knew or suspected would facilitate the retention of that money. The courts below took the view that it was artificial and unjust to view the matter in this way, where there was a single agreement to receive and hold money in a bank account, and when the property wasn't criminal, when that arrangement began to bite. On that point, this court unanimously disagrees with the courts below. This court sees nothing artificial in regarding the arrangement to retain and deal with the property after it was paid into the bank accounts as falling fairly and squarely within the language and purpose of the section. The respondent does therefore have a case to answer, and the appeal is allowed on that basis. The court adds some important cautionary words about the use by the prosecution of money laundering offences. The money laundering offences under the Act are widely cast. Every pickpocket technically becomes a money launderer by merely keeping the proceeds. But that adds nothing to the substance of his criminality. Prosecuting authorities should not add charges under the Proceeds of Crime Act where the conduct is sufficiently covered by substantive offences.
The court is now adjourned.